Hi, my name is Adam Cowie with Cowie & Ward, and I specialize in marital and family law. Today's topic is, when does child support end? In Florida, both parents have an obligation to support their child. The real question comes to, when does the child support end? Typically, child support ends when a minor child turns 18. However, if the child is in high school with an expected graduation date while he or she is 18, child support should run through that graduation date. For instance, if the child turns 18 in November of their senior year with the expected graduation of May of the following year, the child support obligation will continue until the graduation date. Children with severe physical or mental disabilities create a different scenario for Florida courts to determine. If the disability is present at the time of the judgment, the courts do have the authority to order child support past the minor child's 18th birthday for an indefinite amount of time, depending on the disability. However, if the disability is created sometime after the judgment, a parent will need to go seek court relief to determine whether or not child support should be extended. For instance, if the minor child was 5 years old when the judgment was entered and there was no disability present at the time, but when the child turns 12, a disability is created, that party will need to go back to court and modify the judgment to see if the child support could be extended past the minor child's 18th birthday. Although courts don't have the authority to extend child support on a typical case past the child's 18th birthday, the parties may agree to extend child support, for instance, for college or even past that. If the parties enter into a written agreement that provides for that and the court orders it and approves it, that can be enforceable. So for instance, if the parties agree that one parent should provide child support through the 25th birthday of the child and that party fails to do so, the other party can move to enforce that agreement to make the other party pay their child support obligations. There are numerous ways to pay child support in the state of Florida. One way is what's called an income withholding order. This order requires a spouse's employer to pay the child support obligation directly from the employee's paycheck. This amount then gets taken out of the paycheck and paid directly to the state of Florida or directly to the spouse receiving the child support obligation. It's very important that an income withholding order provides a termination date. Without a termination date in the order, the employer will continue to deduct the child support obligation from the paycheck even past the minor child's 18th birthday. Then the payor spouse would need to go back to court to create a termination date. Another method of paying child support is through the Florida State Disbursement Unit. The party paying the child support obligation will pay their child support through the state of Florida, who will then disperse it to the party receiving the child support. This works well for both parties because now the state of Florida has records as to what has been paid or what has not been paid. Another method of paying child support is directly to the other parent. Typically, parents pay this through check, but nowadays more people are paying it through automatic funds transfer through their bank accounts. Parties can set these up, so for instance, on the first of every month, the child support obligation is withdrawn and sent to the other party. A downfall of this method is there's no record keeping in terms of the state of Florida, so I encourage all my clients who pay directly to keep full records of all payments they're making for their child support obligations. For more information on child support or any other marital and family law topics, please visit our website at cowieward.com.